themselves.
Welcome, everyone, and thank you for joining us for this educational event, History of Leopold. My name is Hanif Salam, and I am ACLU of Delaware Smart Justice Campaign Manager. I am joined today with four phenomenal people. Cindy Romer from the NAACP Newark branch, Misty Siemens, a Delaware attorney, Keandra McDole, community advocate and smart justice ambassador, and Nick Baird, a domestic violence advocate. And I think you'll be intrigued by what all of our speakers have to say this evening. As the Smart Justice campaign manager, I felt that it was necessary to educate everyone on exactly where the Law Enforcement Officer Bill of Rights, other known as Leopold Law, came from, when it was implemented, and why we need to pass SB 149 to amend Delaware's Leopold Law. Delaware's Leopold has fueled police abuse incidents by making it virtually impossible to discipline police officers for misconduct or to know any details of misconduct incidents. No other Delaware public employees enjoy equivalent protections when it comes to disciplinary matters. Meaningful changes that promote transparency and public trust must be made to Leopold and FOIA, the Freedom of Information Act. At a minimum, police disciplinary records must be public, and effective independent community oversight bodies must be established. Transparency and accountability are necessary for due process, a fair criminal justice system, trust between our police and communities, and trust within law enforcement agencies. Leopold, for those that don't know, are state laws that limit who can investigate police misconduct and keeps the records of the investigations private. Delaware is the only state that keeps those investigations private forever. Leopold provides police agencies with exclusive power to investigate police misconduct and includes limitations on when, where, how long, and by whom officers can be questioned. The Freedom of Information Act, or FOIA, provides the public the right to request access to records and information from state agencies. It allows community members to be in the know about what the government agencies are doing. State law excludes most police records from being accessed through FOIA requests currently in Delaware. Delaware's Leopold Law exclusively allows police to investigate the police, and it impedes community oversight of those investigations. Community oversight boards should have investigative, subpoena, and disciplinary power, as well as power to study and advise on on policies and practices. Excuse me. The city of Wilmington passed legislation in December of last year that created a citizen complaint review board, but the Delaware Leopold Law impedes that board from operating in its full power. Now you'll hear from Misty Siemens, who will tell us more about the origin of Leopold in Delaware.
Hi, good evening, everyone. I'm Misty Siemens. I'm an attorney from the Delaware Public Defender's Office, and I've been asked to talk a little bit about the Law Enforcement Officers' Bill of Rights, or Leopold, and its history. I'm going to start by talking about the national perspectives on Leopold, and then I'm going to be talking specifically about Delaware. And when I'm talking about the Delaware history, I'm going to go into a couple separate things. I'm going to talk specifically about the history of the law here. I'm also going to talk about the process of it, past, vetoed, past, as well as concerns some legislators expressed in the legislative history recordings that are available. So to begin with national perspectives on Leobor, we all have to remember that these types of laws did not always exist. And what's interesting about Leobor specifically is thinking about them in the context of American history at large. And so what I have found interesting about the Law Enforcement Officers' Bill of Rights countrywide is putting it into perspective on that timeline. So in the 60s, there was what I think a lot of us would consider progressive legislation passed on the federal level. 1964, the Civil Rights Act, 1965, the Voting Rights Act. What was interesting is that in the early 1970s, there began to be a push for versions of what we now know as the Law Enforcement Officers' Bill of Rights. And that started on the federal level. In the early 70s, the first proposed statutory Leobor was introduced in the United States House of Representatives. Variations of that bill have been introduced in nearly every subsequent session of Congress. Now, in 1991, some of you may remember, one of the major things that happened in our police culture history is the Rodney King beating. What's interesting is that same year, that was the same year that a federal version of Leobor got the farthest that it has gotten that I know of in Congress. So Rodney King beating in 1991, and then another version of the federal Leobor was introduced and almost passed both houses of Congress, but passed the Senate in a vote of 55 to 43. This was 2 months after the Rodney King beating. At time, Senator Biden introduced that legislation, and it provided protections for police under investigation. From what I know, I don't believe there's a federal version of this. It's had much more success on the state level. In the 70s, the police unions began to lobby to support the development of police officers' Bill of Rights on the state level nationwide. So some of the first states that passed a version of Leobor: Maryland, 1974, repealed in 2021. Also in 1974 was Florida. In 1976, New York, California, and Rhode Island, 78, Virginia, 79, Wisconsin. In the 80s, West Virginia, Nevada, Louisiana, and Illinois. 1991, New Mexico and Minnesota, and 1994, Kentucky. What we call Law Enforcement Officers' Bill of Rights in Delaware has a bunch of different names in different places. And I'm just going to go through it quickly. If you have any other interest in this, that you can look it up. So it is or was called Law Enforcement Officer Bill of Rights in Delaware, Maryland, Rhode Island, and Wisconsin. It was expanded to correctional officers in Florida. It's called the Uniform Peace Officers Disciplinary Act in Illinois, the Peace Officers Employer-Employee Relations Act in New Mexico, and the Rights and Duties of Police and Firefighters in West Virginia. It should also be noted that police unions began to embed what we consider Leobor in their own contracts as well. And in 2001, Alabama also had introduced something similar to a Leobor, but some people don't consider it a Leobor because it doesn't necessarily go as far as some of the others. In one news report that I found, they do make the connection. In the 60s, we have the Civil Rights Act and Voting Rights Act. And then in the 70s, we have this push for Leobor. I'll leave it up to the listeners to decide if there's a causal or correlative connection there. But it has been discussed among at least journalists that there is a connection. The states that have Leobor, it really depends on what you consider a Leobor. Law scholars and in various things I have found say there's about 14 states with that, or 13 if you don't include Maryland anymore. Other reports like NPR say that there's 20 states with a version of Leobor. In my review of the statewide laws, I think it is 20 now, including Delaware. So now let's talk about the history of Delaware's Leobor. What I think is interesting is that, again, Leo Bore was not always the law in Delaware. There were plenty and plenty of years where the police existed in Delaware and there was no special Bill of Rights and there was no special confidentiality clause. It was introduced, but it was not passed initially. It was then passed in 1985. It's a little bit unclear to me what year it was actually introduced. The legislative history isn't entirely clear and talks about at least it being introduced once without passing, but it did eventually pass in 1985. And I want to read to you all a little snippet from that 1985 recording because I think it's instructive as to some of the problems we still face 36 years later. Representative Sills. The bill would establish a review panel comprised only of police officers to investigate and make a judgment about misconduct on the part of other police officers. That seems to set a dangerous precedent to me, since other governmental employees do not have that particular right. The right to investigate and make judgments of themselves or be in control of the investigative process. It also, that part of the bill, is at variance with an established and a rather sacred principle in this country, namely that the police and the military are controlled by civilian forces and civilian personnel. I wonder if you might explain what it is. What are the circumstances that would justify only police having the right to investigate and make judgment about the misconduct of other police officers? On what basis can we justify that? The sponsor. I think there are suggestions here, and correct me if I'm wrong, Representative Sills, but I don't want to construe anything out of what you've asked, but a suggestion that perhaps we're setting up a situation where the chickens or the foxes are guarding the chicken house. And I don't really see that, sir. What I see is there is a group of individuals, a paramilitary organization taking care of their own. Representative Sills. It seems to me that the administrators who employ police ought to have some right to review the actions of police. I don't feel like you've given sufficient justification for taking that right away from elected officials and other appointed government administrative officials, and give police the sole right to review and make judgments about other police officers. So I took some time to read that because I just think it's so interesting that in 1985, the same concerns that we're concerned about in 2021 were part of the discussion among the legislators. And unfortunately, those warnings, in my opinion, have come true. So that was in 1985 and it passed. So between 1985 and 1994, additional police departments were added. So the bill passes and there's a couple police departments, and then more and more places want to join the Bill of Rights. They want to also have the same processes that these other places have. It's not until 1991 that I have found where there's a confidentiality clause. So before 1991, for those 6 years, there was a Bill of Rights that talked about special due process for the investigative and internal affairs of police, but those records did not have a special confidentiality clause in the law. In 1991, that now is discussed, and it specifically says that police misconduct records are confidential. That new addition, that amendment passes the chambers of the Delaware General Assembly. And let's put that in perspective. When have I also mentioned 1991? Rodney King. So the Rodney King beating is in 1991, and now we have a law being introduced and passed in Delaware, adding a confidentiality clause to police misconduct records and internal affairs. What I also have found that's very interesting, and I hope it's okay to thank John Alfredo from my office. He is our policy director, and he has been absolutely instrumental in helping me with our office's efforts on SB 149 and also on the legislative history of Leo Bore. Found some news clippings about this. And so what is interesting about the passing of the confidentiality clause is that the Department of Justice, the Delaware Department of Justice, did not support a confidentiality clause. So I'm going to read you a couple of news articles that we found that talk about that. And these are shorter than the last thing I read. This was in the News Journal. Attorney General Oberle, in a letter to Governor Mike Castle Wednesday, argued that the intent of this bill is to keep police internal investigatory files out of the hands of anyone except the police. This creates very serious problems in the handling of criminal cases. If the Department of Justice is considering bringing charges against a police officer accused of misconduct, Oberle said, it is absolutely essential that the department have access to all statements taken in the case by police internal affairs investigators. Oberle wants the bill amended to give his office access to the information, though it isn't clear whether that is possible at this late date. And then finally, there's some stuff in the News Journal article from the people who are pro the bill, pro the confidentiality clause. And it specifically says, the police don't want files made available to the public, particularly to attorneys who may be representing clients with complaints against officers. That was the intent of the confidentiality clause back in 1991. So it passes both chambers, DOJ opposes it, and then it gets to the governor's desk. And the governor at the time is Republican Mike Castle. And Mike Castle does not sign the confidentiality clause into law. Mike Castle vetoes the bill based upon the confidentiality clause. The Republican governor vetoed the confidentiality clause. And it doesn't just stop there. That was in the News Journal as well. So the News Journal reports that the aim was to deny access to people considering civil action against a police officer. Attorney General Charles M. Oberle III contended last month that the bill would deny his office information prior to a possible prosecution. Oberle also said that the provision would not withstand a court challenge on a defendant's right to due process. Senator McDowell said he didn't want the Attorney General seeing the police investigative reports. Although Governor Castle acknowledged the shield offered by the bill might be justified in some situations, he said it would diminish the public's confidence by creating an adversarial relationship between two government agencies dedicated to law enforcement, police and the prosecution. All right, I said all that, right? Mike Castle vetoes the thing. And I think from what I've seen in many of the meetings I've been to, I don't want to speak for the Department of Justice ever, but I will in this context. I believe that they would say that they get access to this stuff despite the confidentiality clause. But I also think it's safe to say that on the face of the law and based upon the legislative history back in 1991, the Department of Justice had a serious problem with the confidentiality clause and how it would be handled. Now, I'm going to read from one more document, so bear with me, but I think it's important, right? When the governor vetoed the bill, he didn't just say, I don't want it. He wrote the reason why he vetoed the confidentiality clause amendment. He wrote, the Attorney General has drawn my attention to what may be an unintended consequence of this legislation. He points out that its adoption would preclude the Department of Justice from examining witness statements contained in internal affairs files, even in the course of an active investigation or during the pendency of a criminal prosecution. As the legal representative of the state, the Department of Justice would then be placed in the anomalous position of representing the state's interests without access to all information compiled by the investigating police agency. The identical situation would pertain to the legal representatives of political subdivisions employing police officers. The Attorney General further contends that the privilege apparently created by this legislation would quickly evaporate before a court order issued to protect a defendant's constitutional right to due process of law. Witnesses cannot be permitted to give inconsistent statements to separate divisions of a police agency without fear of discovery or risk of disbelief. Nor should a citizen be subjected to the processes of the criminal law by an accuser whose credibility has not been thoroughly investigated by the prosecuting arm of the government. The duty of the state is to render justice to those accused of criminal acts. Prohibiting the disclosure of pertinent facts obtained by and known to certain of its agents does not assist the state in meeting this responsibility. Nevertheless, I have serious reservations about prohibiting either the state's chief of law enforcement officer or the legal authorities of political subdivisions employing police officers from access to witnesses' statements contained in internal investigatory files. Nor do I think the interests of the state would be served by creating a situation where the Attorney General is required to petition the Superior Court to order a police agency to disclose the contents of certain files. This legislation would just have an unseemly effect. Both the courts and the citizenry rightfully view the state as one entity, especially in the area of law enforcement. We do not need legislation which could diminish the public's confidence in the criminal justice system by creating an adversarial relationship between two government agencies dedicated to law enforcement. So, some powerful words out of the governor's office, especially about the confidentiality clause. So it's vetoed. Well, 1995, it makes its way through and it's added and it's made to the law. We did look for legislative history, specifically audio recordings and other things like that. And there aren't necessarily anything that we've been able to find from 1995. Or at least, yes, from 1995, or at least that's useful here. There's recordings, I believe, of maybe roll calls, but nothing substantive. So in 1996, we have the confidentiality clause, but it doesn't stop there. For one reason or another, it's then decided, actually, we need an exception to it. And that exception was made for civil attorneys who are suing the police for physical injury or damages. So, Bill of Rights, no confidentiality clause. Now we have a confidentiality clause making them secret. And 1 year later, something must have happened because now they have another amendment in 1996 saying, we can give this stuff in civil cases where the police officer has caused physical injury or damage. So those are the major Delaware legislative history pieces that we have been able to find in Delaware. Now, I'll kind of end on this, and I think I've gone over my time and I apologize, but one of the things in looking at the legislative history, and again, I can't thank John Alfredo enough for helping me find stuff, is that history doesn't change. All the concerns back in 1985, all the concerns back in 1991 have come true. And the law as written is not working. And that's why we need SB 149. So in the 1985 recordings, it's actually interesting to note that the police chiefs were not in support of having a police officer's Bill of Rights. There was actually, of the police chiefs council, not one vote in support of the bill. It was 11-10, and it was 11 against and 10 with no position. City and local governments weren't in favor of this law. Wilmington wanted to be exempted. There was talk about paramilitary. There was a lack of removing civilian control of a military type force. It was talking about police chiefs losing power over the people they employ. It was talking about police protecting their own. And it was also discussed that police should be held to the highest standards and should not fear oversight. And then finally, in 1991, there was an additional discussion of that confidentiality clause we talked about. And I'm just going to read this and then I'll be done, okay? All right, so one senator said, "What I do not want to be part of its shielding a law enforcement officer or anyone else from the same exposure and scrutiny that every other public servant is subjected to when they are charged with some serious wrongdoing and violation. There are far too numerous accounts of corrupt police officers across this country, and they give everybody a bad name." The same senator, "All of the good that the police do can be ruined, spoiled by some overzealous cop out here parading around and thinking he's going to take the law into his own hands." And then just the last point, this is a discussion between a senator and a Delaware State Police representative. The senator, "I want to be absolutely certain that no material evidence will be concealed from a reasonable, required investigation into an officer's misconduct. Suppose an officer has done some wrongdoing, like they did in LA, by beating an individual. If that's in the file, can that file be opened up irrespective of this?" Delaware State Police representative, "No, but that's a perfect example. That's the Rodney King event. That would have nothing to do with the internal file anyway. That's clear to public scrutiny. In that case alone, I know it's clearly a criminal civil rights underway by the FBI. There's clearly a 1983 or civil rights violation for civil damages underway in that particular incident. I know that the Los Angeles Police Department are conducting a criminal investigation. That's evidenced by the fact that a number of officers have been indicted before a grand jury. The internal file will speak to the punishment those officers will have to deal based on the rules and regulations that they operate under. There's no material matter concealed. And I'm here to tell you, as I read this amendment, I'm satisfied in my heart, and I mean, that's as best as I can give you. I'm satisfied that it's not going to protect somebody who shouldn't be protected. Finally, one of the senators asked if officers, so one of the points of the bill was that it was to say, hey, this stuff should be secret so police officers can be really, really honest during these internal affairs investigations. And one senator brought up, well, shouldn't they be honest anyway? Why do we need to make it secret for them to be honest? So they can only tell the truth if no one finds out. So that discussion happened, and still about, the bill passed and was vetoed, even despite that. And the Rodney King thing in that particular conversation I went over, if we remember, those officers were acquitted. So this all goes to show, I hope, that there is, I believe, at least some sort of correlation between Leo Bore and some civil rights progress that happened. I think there's a correlation between Leo Bore and reactions to things that law enforcement was not happy with. And I think that it expresses that the time is now, and hopefully we will be able to do it to make sure that the law is righted, and that we don't repeat history in other ways, and especially continue down the path where all of the unfortunate things that were discussed 36 years ago continue to happen for the next 36 years. So I apologize that I went over, but I just thought that that might be helpful to us as we think about Leo Bore and its context and its history. Thanks so much for having me to the ACLU.
Yes, no, thank you so much, Misty. That was awesome. That wonderful information. Normally I jump in to be able to come off mute and be like, hold up, but you just hit so many points and gave us so much information that I think myself and everyone really did need to hear. And while we just take a minute and digest a little bit of that information, Priya has put a link in the chat to the ACLU's website. Please just take a second. If you're not already registered to receive Smart Justice updates, please do so now so that you'll know about all of these awesome events like this one and others that we're doing. You'll get notices of when we have our monthly coalition meetings, and everything that we do, we try to alert people through our email list and on our Smart Justice page of the website. So please take time and join our Smart Justice Updates website. Next, we have two more very phenomenal speakers. We're going to hear from Nick Beard, a domestic violence advocate, who's just going to share with us how Leo Bore does affect victims of domestic violence. And then right after Nick, you'll hear from NAACP Newark's very own Cindy Romer.
All right, everyone, let me just share my screen. All right, thank you. So I wanted to say how unfair it is of Misty to make me follow her up. She did an absolute great job, but I want to make sure that we're really looking at this from the perspective of not just people who are encountering the criminal justice system, maybe being arrested, but also people who are really engaging because they're experiencing something like domestic violence or sexual assault. So I want everyone on here to think about the last time they had a disagreement with a friend or a family member, whether it was anything from yelling at someone who cut you off in the car to, as we constantly have with my son, fights about why mommy can't magically make more milk appear at all times. And I want you to hold that in your head for a bit. Now, I want you to think what it would be like to discuss that with a stranger, not just your best friend, not just your therapist, not just a really reassuring hand, but someone who you've never met before, and somebody who you worry could have all the judgments and all the biases that we all encounter when we're dealing with strangers. I think it's really important to acknowledge that if someone is a survivor of domestic violence, that's what we are asking them to do. We are asking them to talk about really, really intimate parts of their relationship and to share that with someone they've never met before, who maybe they called 911 and showed up, or someone else called 911 and showed up. So I want everyone to try to envision what a difficult circumstance that can be and how vulnerable you would feel in that situation. So we do know that the quality of police response in that circumstance matters. I've spent about 10 years on rape crisis hotlines. I've been the person disclosing, and it really does make a difference how that disclosure is met. There is actual academic evidence that this makes a difference, not just for the person who's actually reporting, but for the rest of the community. In that if there's a sense that when you call with a domestic violence incident, it's going to be met with compassion, with understanding, with accurate advice, that makes a difference. It encourages more people to feel like they can report and to decide if the criminal justice system is a good fit for them. I think we've all heard stories of people who went through the experience trying to acquire a protection from abuse order or reporting a sexual assault and had a horrible experience. And I think we all know that means other people don't want to go through the system. So that's really something that does make a difference. And we do have studies that show it. We also note that the people who call the police are more likely to be people who have an assault history. So this is going to be people who, unfortunately, this is not the first time they've been abused or that they have a history of abuse. And there tends to be some kind of escalation, which means that it's the most vulnerable people who really need support in that moment. I think it sometimes seems like it's a little bit of common sense. You're calling the police if you feel that this is a situation you can't handle and that you're feeling quite desperate or out of control. So just to remember that these are people who are in quite a vulnerable situation. So obviously, it's so essential that we make sure that the police response lives up to the vulnerability and the trust that is really placed in them when they're responding to one of these incidents. So the first problem that survivors tell us they encounter are the mishandling. I was at an event with police lately, and they told me that there have been incidents where they've just arrived at a house and arrested everyone and let the court sort it out. If if any police officers or any lawyers are listening, we don't consider that to be ideal practice. And so we obviously have concerns if police are not handling these incidents in the ideal way or according to best practice. And just to give a plug here, DCADV is always happy to train you so that you can respond better. Another incident, unfortunately, is that there is officer-involved domestic violence and sexual violence. There have been several prominent cases, both I can think of a few in the last few years off the top of my head in Newcastle County and Wilmington Police Departments that made the news because of how appallingly it was handled. There was a very prominent case in Newcastle County Police of an officer who sexually harassed several members of the department. And it seems that, as happens in too many industries and too many fields, people turned a blind eye to it. And it is really concerning to me that while that was occurring, any survivor would have been telling the police officer that story, would have been trusting them with something that is so important and so close to them and something that makes them so vulnerable. The other case I'll mention is the Wilmington police officer who claimed that it was consensual when they had sex with someone who, with a parole violation, who they had threatened to report. I want to make sure that every police officer understands what consent is, understand what is the best practice there, and understands how we treat people who have been through that. So these are the cases that make the news, but what I'm concerned about are the cases that we don't know about. So I mentioned both of these incidents, but I also want to mention that that there has not been a lot of research in the last few years about connections between police officers committing domestic violence. For a lot of reasons, it depends on self-reporting. There hasn't been a lot of funding on it. If someone wants to fund the ACLU, I'm happy to do more on that in Delaware. But older research, particularly from 1991, presented to the Department of Justice is that it's slightly higher than the average population. 1/3 instead of 1/4 of the population encounters domestic violence if they are in a relationship with a police officer. So this is something that I'm really concerned about, wanting to make sure that any police officer who is accused of these things or committing it in their private life is not handling these cases. At our organization, we have worked with several people who are the partners of police officer, and they feel for obvious reasons that that is no longer a safe person for them. This is not a safe place for them to call. And I want to make sure that these are reports that we understand what they're doing in their private life, because it really, really does make a difference into how they are treating survivors and how the community is understanding that we support domestic violence. So I've gone through this without discussing LIBOR, which I know is the purpose of this whole evening, but what does this really have to do with LIBOR? So the first is, as we were saying, the police history and records matter. If someone has several disciplinary issues for their treatment of women, for their treatment of sex workers, for their treatment of survivors, I want to make sure that they're not offering any kind of criminal justice services. Transparency about misconduct is essential. So it's also really important that a survivor isn't sitting there wondering, what did I do? What did I do wrong? Because even in the best of times, it can be really, really hard for someone who's surviving domestic violence not to really feel stuck in that cycle. And so it's really important that we make it clear that if someone is mistreated, that is because of their lack of training and lack of understanding, so that survivors don't feel further disempowered. And really, survivors should be able to trust the system. I think I'm probably preaching to the choir here, and that domestic violence and sexual violence has not always been something that the criminal justice system has handled as well as they should. And there are reasons that a lot of people don't feel comfortable reporting. That's something we want to change. We want to make sure that anyone who feels that that's the best way for them to heal, for them to cope, for them to get protection, has that as something they're able to access. And LIBOR, by making sure that we hold police officers accountable, makes this a more accountable way for survivors to access those resources. And we would say that when we're talking about community-led oversight boards, that if we are making it with police officers, that we're concerned if this doesn't actually include people with experience of domestic violence. I want to make sure that when we're discussing how police should respond to these incidents, that there's someone in the room who says, I've experienced domestic violence, or I'm a childhood sexual abuse survivor, or I went through the criminal justice system and this is what works and what didn't. You know, those are really important voices to be heard. And while they may be civilians, I think it's really, really essential that we promote those. So that's some reasons why LIBOR is so important to survivors of domestic and sexual violence. And I would say for a lot of these, probably anyone who is a victim of crime themselves. I also know that we talked about some really heavy topics. And so if anyone after this really feels like they need some support, I've put up the YWCA sexual violence hotline, where they can listen and just give you any support you might need. Also, I have my email if you want anything from cards to refer someone to more resources. I'm always happy to help. So thank you so much for giving me your time. I really appreciate it.
Hi, thanks, Nick. That was great. Thank you for having us. I will be talking today about community policing and LIBOR. And so I'm going to be throwing out a lot of historical information. So I'll try not to go too fast, but fast enough to move it along. So to talk about where we are today and how we got here, we need to go back in time a little bit. So I want to talk a little bit about the 60s, 70s, and 80s. So in the late 60s and 70s, we see the murder of Martin Luther King Jr. in 68. And we also see the height of Black Power and anti-war movement. The other thing we see is the establishment of powerful police unions. So the International Union of Police was 1979. The National Association of Police Organizations is 78. In Delaware, the Delaware FOP Wilmington was 1965, and the Delaware FOP for the state was 1967. So right around that same 60s, 70s timeframe. We also see the war on drugs campaign kick off in 1971. So we see Nixon pushing mandatory sentencing and no-knock warrants. So then we move into the 80s. And in 1981, we see Reagan become president, and we see him expand on Nixon. So we see him expanding the war on drugs. We see increased incarceration rates. A lot of information has come to light in the past few decades that specifically show that these programs were set up to target the Black communities and anti-war groups. And we see nonviolent incarceration go from 50,000 in 1980 to 400,000 by 1997. So we're seeing phrases like tough on crime and zero tolerance and broken window policies. And so if you're not familiar with the broken window policies, it's really the notion that smaller crimes lead to bigger problems if you don't punish them. So it's a really aggressive form of policing, involves stopping, questioning, frisking for really low-level offenses. So you start seeing the police enforcing things like jaywalking and littering. And let's guess which communities they're doing the enforcement of that in. The other thing we see in the 80s is re-kickstarting of the militarization of police. So you're starting to see federal dollars being earmarked for military-grade weapons for police departments across the country. The other thing is in 1984, we get the Comprehensive Crime Control Act, which gives minimum drug sentences. And this one's interesting, the Anti-Drug Abuse Act of 1986, which gives harsher sentences for crack versus powder cocaine. Which communities do we see the crack cocaine being much cheaper versus the powder cocaine? So again, really targeting minority communities. So now that we know what's going on nationally, let's talk about what's going on in Delaware. So in the 80s, we really see Delaware, and specifically Wilmington in this case, increasing their presence as a financial sector. So there was some tax law changes that happened in the 80s that made it financially lucrative for banks and other financial organizations to move in. So we see a lot of like big business coming into Delaware, but on the flip side, we're also seeing rising poverty and crime, and we're still seeing racial tensions. So by the 1980s, the police actually are still operating under certain guidelines of community policing. So they're on the streets, they're on foot patrol, they're interacting with the community. Sounds like a good thing, right? But they're also operating under this Nixon and era Reagan of tough on crime. So instead of working with the communities, what we're really seeing is they're in the community, but they're over policing the communities. So a couple of things we've got going against each other. We've got businesses being recruited to come into Delaware. And of course, the government wants the city to look good for these new businesses. So then we see the police are more likely to crack down on low-level crimes like graffiti and vagrancy, and really over-policing of the minority communities that are already suffering because of financial issues and poverty going on in their communities. So 1985 pops along and Leobor comes to Delaware. So now we've got racial tensions between the public and the police, but now the public has almost no insight into why an incident occurred. So they don't know what could have been done to prevent it. They don't know what disciplinary action happened. They don't even know if an investigation happened. So imagine that you're a citizen who is facing police misconduct and you'll hear from other speakers today. And Nick was talking about domestic violence victims having to have these conversations with police. So you have this bad interaction. You don't know anything about it. You don't know what happened. You don't know if they looked into it. They could have fired that police officer because they found him guilty, and you won't see that information. So it's really an unbalanced situation. So the thing about community policing, if it's going to be effective community policing, is that it really involves the police working with community-based organizations and governments and religious organizations, and really working within the community to fix some of these issues. Because the reality is the police can't fix poverty in in an area. They need to work with those organizations to do that. But how can that be done when you don't have any trust, you don't have transparency, you don't have accountability? Like, it just can't. So the creation of Leobor in Delaware really solidified that like unequal dynamic, because the police have the institutional power. And now, because of Leobor, they have the legal authority to keep any misconduct secret. So it really led to and leads to a continued distrust, and us versus them mentality, which we can still see today. So really just to kind of summarize that, we've got tough on crime policies, over police communities, militarization of police, increased poverty, systemic racism, and zero insight into police misconduct. What could go wrong? So we have a lot to do to reverse systemic racism in policing, but changes to Leobor are really the bare minimum. So, you know, what Misty was saying earlier about the themes when she was doing her research, I found the exact same thing. There were times where I would be doing research and I'd have to scroll back because I'm like, was this last year? Like, the articles are so relevant, like the themes of accountability and transparency and community engagement. They're just the same things that we've been seeing for decades and decades. So thank you for your time, and we'll answer questions in the chat. And I'll hand it back to Hanif.
Thank you, Cindy and Nick, for those both great presentations. I think that our viewers on Zoom and Facebook would agree what I said in the opening, that we had some phenomenal speakers tonight, and it has really been great presentations. So for everybody that is watching us on Facebook Live, I want to ask you to take a minute. If you're not following the Delaware Campaign for Smart Justice page, just take a minute and follow that page so that you could also stay up on what we have going on with Smart Justice. So we have one more speaker before we get to any questions or comments that any of you may have. And I know that she's going to be just as great as our first three speakers. Next, we'll hear from Keandra McDole, community advocate and Smart Justice ambassador.
Hello, everybody. My name is Keandra McDole. For a lot of people, I don't know if you all know me or not. My brother, Jeremy McDole, was executed September 23rd, 2015 by Wilmington, Delaware's police firing squad. My brother was shot 16 times. The only reason why he was still up in his wheelchair was because the bullets were keeping him up in the wheelchair. We have a lot of stuff to work on. I wrote something tonight. I normally don't write anything, but I didn't want to use no type of profanity and stuff. So I'm going to read what I wrote. SB 149 needs to be passed without any types of amendments. The Law Enforcement Officers Bill of Rights protects bad officers. It makes it impossible to hold any officers accountable for their misconduct. There is actually an officer by the name of Alex Marino, who is actually an officer in the Wilmington Police Department. Officer Alex Marino is known in my communities and in our neighborhoods as a cop who loves to abuse people in our communities mentally, physically, and emotionally. Officer Alex Marino likes to harass me in person as well as on all social media platforms. I have submitted numerous complaints about this officer, and after the investigation is completed, the results always come back as the officer did absolutely no wrong. Why is it impossible for me to be able to look and see if this officer has harassed or abused anyone else? You want to know why? The issue is Leobor. The issue is the police investigating the police. We have another officer by the name of Officer Waters. He is the officer who physically abused Mr. Dwayne Brown by over and over and over slamming his head against an obstacle in a convenience store in one of our neighborhoods. SB 149 needs to be passed without any amendments. It's a slap in the face to every citizen in the state of Delaware while these government officials play around with our lives by this bill still not being passed yet. These government officials are too concerned with how the police and police unions feel instead of protecting us, instead of saving our lives. Every second these government officials takes to bullshit around with passing SB 149, they are allowing these crooked officers to continue to get away with executing us, to continue getting away with murdering us, and lastly, abusing us. It's disgusting that we in Delaware have to work overtime to ask for police accountability, knowing these murderers are currently have always been out of control. The police are here running around like kids with no adult supervision. SB 149 should have already been passed without any types of amendments. We should be on this phone call right now, speaking about things in reference on what can we do with community policing. There can be absolutely no community policing until SB 149 is passed. Nobody in my communities and my neighborhoods trust the police. They're out of control. Thank you.
Wow. Whew. Heavy words, sis. My goodness, I'm supposed to close it out. I should have maybe left you to do the closer. Whew. Okay. So as we've heard tonight, the original intent of Delaware's Leopold statute was to create a set of guidelines that would ensure due process for police officers who have been accused of misconduct, so that all officers receive the same treatment throughout the state. So how did we go from a statute that intended to create a uniform standards pathway for police discipline to a statute that prevents police from being effectively disciplined when they violate the law and the rights of Delawareans, committing violence against our communities in Delaware? How do we get to a point where cops can murder unarmed Black men and not be held accountable in Delaware? The time for change is now. Our legislators should be anxious to pass SB 149, not now, but right now. The Leopold provisions requiring all misconduct records remain confidential must be repealed. All records relating to police misconduct and investigations should be made public and subject to FOIA. And the Leopold provisions that gives police departments exclusive authority to investigate their officers' misconduct must also be repealed and give community oversight bodies investigative, subpoena, and disciplinary power, as well as the power to study and advise on police policies and practices. This is all language that is currently included in SB 149. We had a law enforcement accountability task force that was held last year during the legislative session. And through the results of that, Senator Lockman submitted SB 149, the current bill we have. Now our legislators are dragging their feet, slow walking the process, discussing amendments and changes to the bill when SB 149 does exactly what it needs to do. We need to amend the Leopold to allow for transparency and accountability so that we can have better, safer communities, and we could build trust between the police and our communities in Delaware. I like just to take a moment right now to see if we have anyone that is on Zoom that has any questions or comments. You could use the raise hand function to be able to ask a question or comment. And anybody watching on Facebook, if you had a question, feel free to put in the comments and we'll address it. What you can do to help this move forward is, for one, there is a link in the chat to support SB 149. You can click that link to sign the petition. You can contact your state representative and senator because this bill would be going up in the Senate first. You can contact your state senator. If you do not know who your senator or representative is, you can go to the General Assembly website, which is legis, legis.gov. And that is currently in the chat. Thank you, Cindy, for putting that. So that's what you can do to move forward. And you can also be sure to look in the chat and register for Smart Justice updates so that you can join us as we continue to plan and organize to ensure that we get SB 149 across the finish line. Well, I don't know about our viewers, but I know for myself, I learned a lot from all of our speakers, and Keandra just gave me the fuel and energy to continue doing what I do to make sure that I am advocating for smart justice all across Delaware, and that we do everything we can to ensure our legislators pass SB 149 in this legislative session. So I'd like to thank Misty, Nick, Cindy, Keandra. A big shout out to our communications department at ACLU Delaware and Priya for facilitating this event tonight. Big shout out to all of you that have watched and joined us tonight on Zoom and on Facebook. I appreciate you all, and I hope to be in touch or to meet you all sometime soon.